is DME TV, and you are watching your program DME Dialogue. This is a program in which we invite distinguished people to speak on different areas of their expertise, and we also try to know the various facets of the personality of that person and the social interface and the contribution that in particular discipline that person would have made, which obviously will make our viewers more enlightened on those issues. And we are very happy to tell you that today we have with us Dr. Aman Hingorani, who is a lawyer in the Supreme Court of India. He is an advocate on record. He is also a mediation lawyer. And beyond that, he is an academic person who has done his PhD on the Kashmir issue. And otherwise, also, he has been contributing in law education on the academic side in various capacities. Thank you, Dr. Hingorani, to be with us. And it's really a very rare occasion that we have called you to this studio and to talk to you and knowing more about you and the contribution that you have made.
Glad to be here.
So, to begin with, firstly, we would like to know about as to how you entered the legal profession, what all happened, which motivated you to come to this, and how have been your journey as your education and then joining the profession.
Well, I actually wanted to be a doctor,
Yeah.
and I had a fascination for science, and actually did my BSc, in which I again went into genetics and was thinking of following it up with biotech, but I think law was in the blood because I'm a fourth generation lawyer.
Oh, great.
So my great grandfather, my grandfather, my father, my great grandfather and grandfather were judges, and my grandfather was a senior advocate. My mother was a barrister, so it was in the blood. So eventually, after doing my graduation in science, I just came back to law. Not only I, but I have two sisters. Both of them also came to law. So all five of us in the family were lawyers.
Oh.
So it is interesting and a fascinating area to be in because I enjoy the subject of law. So I have done different roles as mentioned, but they all are within law. So whether it's mediation, or writing, or teaching.
So it has further transferred also, your sons and daughters are also.
No, my son is still very young. So I don't know whether he wants to do law, but my wife is a ENT surgeon. So he has a choice of getting into medicine or law or whatever he wants to do.
So how have you been enjoying practicing law?
Law, you see, I've always enjoyed law more because of it being an instrument of social change. Um, my parents started the remedial jurisprudence of PIL in the country with a trial business case in 1979, where the proposition that any person can move the court for protection of the fundamental rights, and it's the duty of the court to ensure that the fundamental rights are secured. Um, that kind of jurisprudence where there's no list or dispute between the parties, like in a trial business case, people are languishing in jail for 10 years, 20 years, for 30 years without trial. For an offense where the punishment was, say, 5 years. So even had they been tried, convicted, given maximum sentence, they still would have been out. So you can't keep people in jail like that. So there's no dispute. But the people were there because of no reason but poverty. So when my parents filed this PIL in the Supreme Court in 1979, that led to a result that resulted in the release of an estimated 40,000 people in 6 months. And then your Bagul Blindings case, Rudal Shah's case, Ranchi Mental Asylum. So as a child only, I was exposed to these kind of matters. In fact, as a law student, I had filed a PIL in the Supreme Court on behalf of 25 million citizens suffering from fluorosis because they were forced to drink contaminated underground water in the absence of potable water. And the Supreme Court did entertain the matter and issued notice to all the states in the country, and then the drinking mission project was set up to provide drinking water. So these matters, and even during practice, a lot of these cases are I'd filed PILs for inmates of under mental asylum.
So the cases that you refer to, which your parents took up, and you have been taking up these kinds of issues related to human rights and all.
Human rights, and
Yeah.
also cases of miscarriage of justice. Like I was appeared for the Council for Nirvaya's family to see whether we could have the juvenile
Hmm.
who knew the nature and consequences of his actions, despite being a minor, despite being a juvenile.
Hmm.
Could he be tried for what he did? Because we challenged the constitutional validity of the JJ Act to the extent it gave blanket immunity uh, to a person under 18, not
But how
16.
do you take up such cases? Whether you are approached by the concerned party, then you
In
take
this
up.
case, we were
Oh.
approached. For Nivea, we were approached, but a lot of cases like the fluorosis matter or the argument asylum, we saw what's happening in the newspaper reports or what the a TV program or somebody's done a documentary on it.
Hmm.
And we will feel these are people who are the marginalized section of society. They have no access to courts.
Hmm.
So you need to bring their situation before the court and
Hmm.
tell the court that we brought the violation of this, we brought to your notice the violation of these human rights.
So, do you find legal practice an instrument for social change?
Yes, I mean, a substantial part of my practice is about doing pro bono work to make law meaningful for people. You see, we have had quite a liberal Supreme Court, which has gone beyond many courts in other jurisdictions in trying to protect human rights. I'm talking about the phases of, say, 80s, 90s. Of course, there has been a backlash against PIL, and not all judges would necessarily favor PIL. I mean, you would have some good judges, some bad judges, some more indifferent, or some judges who are unpredictable. So you don't know, but more or less as an institution, the Supreme Court has established the jurisprudence that for people who are voiceless or marginalized or destitute, the courts will be proactive in trying to protect their human rights.
But if you go into the genesis of this PILs, don't you feel that if we are more dependent on PILs for the delivery of justice or for social change, this somehow indicates that the existing law, structure of law and the existing structure of judiciary is not actually doing well?
You see, the uninterrupted prisoners case happened because there was a breakdown of the criminal justice system. That's why people were there for years without trial, uh, simply because they were too poor. Some of them didn't even know why they were there. They were on strike to tell the state to say, why are we here? So there was a breakdown of the criminal justice system, and that's the reason why these cases came. But the PIL, as originally conceived by my parents, was more to do with protecting the rights of the poor. In cases where there's no list or dispute, like you can't blind people, you can't tie mentally ill people to beds and deprive them of medical treatment. So there are cases where there was no list. Later on, Supreme Court, with SP Gupta's case in 81 and other matters, they expanded the scope of PL to bring in class actions or class standing cases relating to pollution, environment, rule of law, which could have been litigated within the traditional system, but which, according to me, has diluted the original concept of PI.
But for the last many years, what I have found that the courts are not very much for PILs, and in some cases, the judges feel that these are not the public interest litigations; they are more the private interest
Some
litigations,
cases, see,
and some fines are even imposed.
PI has been misused by people for ulterior motives. There's a rival industrialist whose industry want to close, complain against it for being polluting, etc. That's misuse of PIL. But the reason why this misuse has happened is because, according to me, the Supreme Court has unduly expanded the scope of PIL. All these cases, complete with the check and balances, could have been litigated within the traditional system, whether there are pleadings are there, evidence is there, etc. PIL, according to me, should be confined to for only to the kind of cases for which it was initiated. That is only for the poor or the marginalized who don't have access to court and where there's no list, there's no dispute.
Yeah.
So the people who you can't say a person can put in jail for 40 years or trial. There's no dispute about it.
But referring to criminal justice system in the country, do you feel that there is something wrong? Because what I can find, and many scholars have pointed out, is that this whole system is an instrument in the in the hands of the state, and whatever they want to do, they simply get it done.
You see, at the end of the day, judiciary is very much part of the state, and what happens in society is reflected also in our institutions. Number one. Having said that, our at least the superior judiciary in the past has been quite bold and innovative in trying to do some actual to go try to bring justice at the doorsteps of millions of people. So as it's not a question of it being the best option. It's a question of last resort. When the executive fails you or parliament fails you, where do you go? You go to the courts. And there, if you get a sympathetic court who says, yes, we'll protect your human rights, is bound to enhance the credibility of the institution. But as a litigative strategy, the amount of concrete relief PI has delivered to millions of people in this country, nowhere in the world that has happened. So yes, our system, I would say, is not in the best of state of health. We have the delays are notorious. The There's a lot of controversy which is going on. There's a lot of articles have been written on the collegium system, appointment of judges, judicial accountability, on the issue of courts not giving superior courts not giving reasons for the decisions in the particularly the Supreme Court. Um, so they are the structural things which need to be addressed. So there is a debate, there are discussions, but if I just compare our judiciary with the judiciary of other countries, I think we are much better in that comparison. Of course, the house needs to be set in order, but then judiciary is this is something which is not new. It is for donkeys years we've been saying we need to revamp our system.
Yeah, and talking about mediation, since you have been a mediation lawyer, what do you find whether mediation is successful or should have been more successful? Because in our country, we find there is too much pressure on the courts as far as litigation is concerned. Whether mediation could be a solution to a lot of such cases which otherwise will go to
See,
litigation.
mediation is something I started teaching in 1998 in Delhi University. And once we basically have institutional mediation in this country. So whether it's a course or things like PhD or FICI and so on and so forth. Once these institutions were there, I was empaneled as a mediator with them, with the Supreme Court and the Delhi High Court. And mediation, I find, is effective. You see, not every case is suitable for mediation. So you can't have cases of heinous crimes or constitutional matters being referred to mediation. But the kind of cases that can be referred to mediation, like matrimonial disputes or labor matters or IPR disputes, check bouncing. So there's certain kind of matters that can be referred, and for that, mediation, I think, is a better way of resolving that particular conflict. So I don't really treat mediation as alternative to the formal legal system. I think certain cases are better resolved through the court. Certain cases are better resolved through mediation.
We take refer to the most live case which is happening, this Ayodhya dispute. That the Supreme Court wanted that through the mediation the case is resolved. It did not happen, and now the court is.
Much has been written about why perhaps the Ayodhya dispute was not a suitable case, was not, a case ripe for for mediation. There are many factors which are involved, which I mean, given due to shortage of time, one can't get into. But mediation as a process is one which can help in rebuilding relations so that you have a better society. So, arbitration, according to me, is not very successful in this country. Mediation has a potential of being very successful because it is cheaper, it's faster, parties decide, so it's more durable. It's a question of empowering the parties. What we need in this country is training people to be effective mediators. Our training manuals of the institutions which I referred to, according to me, are quite effective. And I have in many of my writings pointed out what those defects are. There needs to be a relook at the way we at the curriculum of mediation and the teaching method on how we train mediators. So it's to make it more effective.
And talking about your academic side, since you are too much into academics, you have done research. on a topic which is so debatable in India and which everybody feel concerned about, that is Kashmir. So can you tell us about your research on Kashmir? How did you do that? What all efforts you did and how it culminated into the book that you have written?
You see, after I did my master's, I was looking for a subject to do my doctoral thesis on, and my father was a pre-partition lawyer. He was a lawyer in 1944 and enrolled with the Sindh court in 19 March, 27 March 1946. Later, he came to India and joined the Supreme Court. He told me that look at the Kashmir issue because though it's a political issue, every conceivable principle of law has been turned on its head to create and sustain this issue. So I started research in 1995. I completed my given my doctoral thesis in the year 2001
Of which university you?
at Delhi University.
Okay.
And I gave it in 2001, and the book basically builds on that thesis, on the proposals I had made at that time. At that time only, I had pointed out that our approach towards resolving Kashmir has been flawed right from 1947 itself. We need to have a very different approach, a very novel approach, which I put in the book.
I have a question here.
Yeah.
You completed your PhD in 2001, but your book came out perhaps in
2016.
2016. So how this 15, 16 years took in taking out the book?
For initially, it took me 3 years, almost 2 to 3 years to get the degree because of some objection or the other that this book is perhaps too sensitive, or this things are too sensitive.
Yeah.
And after that, what I did was I tried to update it to see because there's no point publishing something which had and Kashmir is ever evolving. So I needed to publish it. In fact, the first edition came out in 2016, and which was updated up to Pathankot.
So you would have done a lot of work during last 15 years to make it updated.
Yeah, continuously to update it, and then even after 2016, after it was published, and after within 10 months of the book being published, Pakistan had recalled a UN a resolution that given in 1960 to the ICJ, which require, and then China came out with this whole One Belt One Road initiative, the blueprint for it. As a result of which, I again had to rework on it, and there was a 2017 edition in paperback. And now with the 370 moves, there'll be yet another. We are still looking at bringing out yet another edition. But the point is that this whole like I as such have nothing to do with Kashmir. I have not, and which is the reason why I felt.
You did it very dispassionately because you're not party of it.
Precisely. So from being distant from the subject, without getting bogged down with emotions, because it is a volatile issue in this side of the world, to see it dispassionately, objectively, to see, and I looked at it as a case, purely out of academic interest, that if these are the facts, which I culled out from British archives or from the UN Security Council.
Yeah, this is also I wanted to know. I mean, during your research when you are doing your PhD and afterwards, till the time you took out this book, what kind of researches you did and how you did it, what sources you actually used?
You see, as my basic source, I would say, which is the primary source, would be the UN Security Council debates. Reports, the verbatim reports right from 1947 to 1971, where reconstructed what happened in this UN Security Council, so as to move backwards to show why we were made to go to United Nations Security Council, which was a trap laid for us. The Security Council was being subverted to get Britain to get Pakistan de facto control of the occupied territory and make that territory available to Britain for its great game against Soviet Russia, the politics behind it. So I could reconstruct from there as to why each member state of who were there in the Security Council, why they were taking particular stand, work backwards, and then by the time I was working on it, the British archives had been declassified. And then you had certain books of Sarila, for instance, and you have Ali Khan, etc., who have reproduced extensively from those British archives, which then I matched with my research here to be able to understand the Kashmir issue in context of the colonial politics of partition, how it was the British which created the Kashmir issue for their geopolitical gains, and how we messed up right from 47 without understanding it.
How did it happen, if I should ask this to you? I mean, why government of India right from 1950 till date, and all the governments, they have been committing some of the other mistakes as far as the legal interpretation of the whole thing or the policy measures that government have been adopting.
You see, the archives and the research establishes that partition was scripted, and partition was scripted. Was the partition was conceived
Much before 1947.
right way back in 1940 itself,
Yeah.
when there's a telegram from the Viceroy to Secretary of State saying that maps of India and Pakistan have been drawn up by member of the Viceroy Council, Zafrullah Khan.
Mhm.
So right from that point of time, there was this thing, and the reason was that the Britain wanted a slice of India for its great game against Russia, and they wanted Northwest Frontier Province, and they wanted Gilgit-Baltistan region of J&K, which formed the Islamic crescent right from Turkey to China. So for their own geopolitical games, the details are there in the book. But the what is surprising, which is not in public domain as so much, is that J&K, when succeeded to India on 26 October 1947, it became an integral part of India, the entire state, as per the very law which created India and Pakistan.
Yeah.
Because India may be ancient civilization, but India and Pakistan are creations of British statutes, modern day India and Pakistan. We could have done away with that law. We chose not to do away with it. So there's no doubt of the legitimacy of India and Pakistan, recognized as sovereign countries. J&K, which was sovereign before it acceded, became an integral part of India, which made northern areas integral part of India. So I've documented how the British carved out the northern areas on the night of 31st October 1947, Indian territory, hoisted Pakistani flag there and asked Peshawar, you take it over. And how the British helped carve out what we so-called Azad Kashmir as a buffer area between India and Pakistan to preclude India from going to war against Pakistan.
You have done an academic
So,
work.
if that is the situation, these two areas were earmarked by the British to be kept free from Indian control. But what we did is, when the ruler came to us, and then of course I talked about how the British, for in a way, persuaded the then government of India to commit to a plebiscite, and then go to the United Nations to internationalize it, so as to make the entire area disputed. So it's India which has gone to the United Nations.
So my question is that you have done an excellent academic work which has come out in the form of a book. But then, how to change the perception of the people, particularly the common people? I mean, what can you suggest to take the right kind of things and as to
No, I
what
think
exactly
facts,
to the common people?
these facts must be put out there. The partition scripted Kashmir issue itself is a product of British politics, and our leaders of undivided India simply did not rise up to these challenges. You had the ruler acceding unconditionally to India. It was New Delhi which viewed the succession as provisional in 1947. It was this provisional accession which gave a disputed territory tag on the state. It was India which internationalized the Kashmir issue. It was India then which simply subsequently said territorial status quo, let them keep what we have, despite the 1994 parliamentary resolution. So we win Haji Pir in 65, we give it back to them, though it's Indian territory. We ignore what's happening in China occupied Kashmir. China has taken away about 20% of Kashmir. And we simply boycott the One Belt One Road Forum. Our policy is, the result of our policy is that we are disowning our people who are Indian citizens under foreign rule. Even they have lost consciousness of being Indian citizens.
But then, what's the way out in
So
such
the
a
way out in this situation is, according to me, is to first remove the disputed territory tag on J&K, which we ourselves have given it. And the way forward for that, which is put in the book, is to go to the ICJ to say the same law which created India and Pakistan makes J&K part of India. From where did the government of India get the authority in 1947 to say people will decide the future of the state, when the law which created India said the ruler will decide?
Yeah.
So if that goes, your UN resolution score. If the ICJ says that the entire state, northern area, the so-called Azad Kashmir, Jammu, Ladakh, and the valley is part of India, it changes political discourse. Law can't resolve Kashmir issue. But a finding in law that we are entitled to the entire state will change the political discourse, change world opinion, will give us moral rights and the legitimacy to go to the people of JNK and say you're part of India. There's no question of plebiscite.
Right. So thank you, Dr. Hingorani, to tell all these details which are normally not known to the people and to throw light on PIL and so many aspects of law. And we hope that whatever you suggested, it goes further and India or the Indian government decide to go to ICJ, and let us
The
hope
political
that,
decision.
yeah, so the things sorted out. So thank you for this. So this was our program DME Dialogue with Dr. Aman Hingorani, and you are watching DME TV.